To say it has not been difficult for us to convince Congress that there's a problem here. We've had a lot of bipartisan interest in overturning these Supreme Court decisions. We had a bill introduced called the ADA Restoration Act. The business community thought it went too far. And the main concern that the business community had is that we basically took out the words that substantially limits a major life activity. So that law, if it were to become law, would just say you're protected under the ADA if you have a physical or mental impairment, you have a history of an impairment, or you're regarded as having an impairment. The employer community, the organized employer community said, wait a minute, that's going to protect people with common colds, that's going to protect people with the flu, that's going to protect people with tattoos, whatever. They came up with their parade of horribles, and they said, this doesn't work. So we sat down with the employer community, and that was the U.S. Chamber of Commerce, the HR Policy Association, the Society for Human Resource Management, and the National Association of Manufacturers, and we negotiated a compromise that they could live with and we could live with. That compromise is called the ADA Amendments Act. It passed the House 402 to 17 on June 25th. I'm going to say that again. It passed the House 402 to 17. That never happens. Okay? The original ADA, which was a bipartisan love fest, had 378 votes in the House. We had 402. Okay? So we came over to the Senate with a lot of momentum. Senator Hatch thought that he needed to put his mark on the law, so we made some changes to accommodate Senator Hatch. That bill got introduced right before the August recess. It now has 73 co-sponsors in the Senate. 73 out of 100. Not bad. And that includes, guess who's thinking about coming on as a co-sponsor? Coburn. Okay, Coburn is the senator who's called Senator No. He stops everything, okay? And he's thinking about co-sponsoring the bill. So we're excited. We got a lot of momentum. We think this thing's going to pass in the Senate. I'm going to briefly describe the compromise, and we can get into this in Q&A. If you want to get a lot of information on this, go to adabill.com. That's a joint website that we did with the business community. It's called adabill.com, and that will give you more information than you want about this bill. The House bill overturns Sutton and says that you do not consider mitigating measures when you're looking at whether somebody's covered. You do consider them on whether they're qualified. But when you look at whether they're covered, whether they do have an impairment that substantially limits the major life activity, you do not consider mitigating measures. That's huge. Right there, if we just pass that, that would be a huge improvement over current law. It also says that the definition of disability should be interpreted broadly. That overturns Toyota versus Williams, where the court said it was a demanding standard that should be narrowly interpreted. So that sends a clear message to the court, you got it wrong. It also has a broad regarded as prong, where it says if you're treated or regarded or perceived as having a physical or mental impairment, you're covered under the regarded as prong. You don't have to show that the employer thought that your impairment substantially limited major life activity. If you experience adverse treatment based on the employer's perception of your impairment, you're covered. That doesn't mean you're going to win your case. It means you get to the issue of whether you were discriminated against. So that's going to do a lot of good. And then the hardest thing for us to negotiate, well, just one other positive thing before I get to the hard part, is that when you're looking at episodic conditions, and a lot of non-impairment disabilities are episodic, you're looking at episodic conditions, you look at those conditions when they're manifesting, when you're determining whether they're substantially limited, and the courts have been split on that issue. But going to the issue, the hard thing to negotiate, that was the first prong of the definition. The business community likes the term physical or mental impairment, and I know you guys are the business community. I'm not telling you what you like, I'm telling you what your lobbyists in Washington like. The Washington lobbyists for the employer community like the term physical or mental impairment that substantially limits a major life activity. They don't want to touch that. So we had to get creative with them. And on the House side, we said, okay, then let us at least define the term substantially limits in a way that sends a clear message to the courts that it's not prevents or severely restricts, which is what the court said in Toyota. So we came up with a new term, materially restricts. So we defined substantially limits as materially restricts, and then in report language on the House side, we said materially restricts means more than moderate, but less than severe or significant. That was a nuanced compromise that Senator Hatch didn't like. He didn't like it that we had a term, a new term, that was not defined in the statute. Neither did the White House. The White House didn't like that either. So, notwithstanding the fact that the business community liked it and the disability community liked it, Senator Hatch and the White House didn't like it. So we sat down with Senator Hatch. First Senator Harkin did, and then we all came in and sat down with Senator Hatch and worked out a compromise where in the bill that has been reintroduced in the Senate, it says that we are overturning Toyota versus Williams, and substantially limits should be defined as less than prevents or severely restricts, and less than what the EEOC said in its regs before Toyota, which was significantly restricts. So we're just saying that the bar needs to be lower. We're not saying how low. The compromise that Senator Hatch and Harkin came up with is put the bar down at moderate and say it's more than moderate. Harkin thought that was a huge victory. We said we don't want that. We said we'd rather have no bar. And the reason we said that is go to the way that moderate word gets used in the context of other diagnoses, like mild mental retardation. If somebody has mild mental retardation, are they going to be told that they're not protected by the law because it's not more than moderate? We just didn't want to get into that kind of terminology. So we're saying the bar needs to be lower than prevents or severely restricts, lower than significantly restricts, but not saying where it needs to be. And we're working on the report language for that right now on the Senate side. My prediction is that bill will pass the Senate with over 90 votes the first week they get back in September. It'll get sent to the House. The same bill will pass the House, and it will be signed by the President. I'd say the chances of that happening are 50-50. Some of it depends on Senator Kennedy's help. If Senator Kennedy comes back and leads that process, it's a slam dunk. If he's unable to come back, I still think it'll happen, but it's going to be harder. So keep your eyes on it. If we don't pass it in this Congress, I guarantee you we will pass it in the next Congress. Senator Obama and Senator McCain are both co-sponsors on the Senate bill. They both said publicly that they want this thing to happen. And Senator McCain actually said publicly that he supported the House bill, which was great because the House bill was more controversial than the Senate bill. So I think we're in pretty good shape on that, and I'm happy to answer questions on it.